In this week's Kapihan sa Manila Bay, two institutions of laws and the Constitution. And I'm very proud to be with them today to hear their thoughts and their opinions. And we will discuss today the Supreme Court decision on in dismissing the impeachment case against Vice President Sara Duterte. They need no further introduction, but I just would like to ask everyone to warmly welcome our guest for today, retired Justice, Senior Associate Justice Antonio Carpio, and former Constitutional Commission member and former Chairman of the Commission on Elections, Christian Monsod. Good morning, gentlemen. And in deference to the events, the big events that are now history in a part of our Philippine history, we'll just ask you to give your opening statement on the subject matter. We'll start off with Justice Carpio, please.
Thank you, Marichu. Basically, Sambayan, which I chair, is opposing disagreeing with the position of the Supreme Court. For two reasons. First, the plenary actually voted to approve the fourth complaint and to send it to the Senate. So the finding of the Supreme Court in their decision that there was no plenary approval of the fourth complaint is totally wrong, because that's not what the records of the House show. There was an actual vote by the plenary to send the fourth complaint to the Senate. And after the fourth complaint was voted by the plenary to be sent to the Senate, the House plenary archived the first three complaints. And after that, the Senate received the fourth complaint at about almost 5 p.m. and the House adjourned 2 hours later at about 7:15. So the Supreme Court said that the one-year bar rule started to run when the House adjourned. So when the House adjourned, the fourth complaint was already approved by the plenary and it already reached the Senate. So obviously, the one-year bar rule cannot apply to the fourth complaint. The fourth complaint was filed on time. So it's a very basic error there, and I think it deserves to be reconsidered by the Supreme Court. The other major issue is that the Supreme Court imposed new requirements to the filing and initiation of the impeachment complaint. Before, in the Francisco ruling and in all other previous impeachment complaints that were filed with the House, there was no hearing at the plenary level, because the hearing happens at the committee level. When the plenary refers the impeachment complaint to the Committee on Justice, that's where the hearing occurs. And this was always the practice, and nobody in the world knew that there has to be a hearing at the plenary level. It's a new requirement. So, and the Supreme Court imposed this new requirement retroactively. How could the House have complied with this new requirement when it never existed when the House took up the first 4 complaints? In other words, how can you comply with a requirement that never existed when you performed the act? There's a rule that when you overturn a doctrine, and the doctrine is there in the Francisco ruling, when you overturn a doctrine, you have to apply it prospectively because there is a violation of due process if you make it retroactive. Because if you say that the House should have conducted a hearing at the plenary level, could not have been complied with because the House never knew that there was such a requirement. All the previous cases never went through a hearing. It was not in their rules. There was no Supreme Court decision that they have to do it. And under the Constitution, they have the power to make their own rules. So when you adopt a new doctrine that reverses the old one, you have to apply it prospectively because acts done under that old doctrine at that time, before the new doctrine took effect, are valid. The rule is if you have a new law or if you have a new regulation, the people concerned must be informed actually or constructively. Constructively, if, for example, the law is passed, it's published in the newspapers, everybody is presumed to know the law. That's constructive. But if if there was never a law, never a regulation, it was only adopted later on, how could you apply it retroactively when nobody knew about it and nobody could have complied with it because the law never existed at the time? So if you hold someone liable for an act that was not prohibited at the time he performed it, that violates due process. Because you have a right to be informed that this is the law, this is the regulation, and you have to follow it. But if the regulation or the law was not yet enacted, how can he follow it? It violates basic due process. So that's why we're saying this new doctrine of the Supreme Court cannot be applied retroactively. It cannot be applied to this case. Future cases maybe. But there's a third ground. And Commissioner Monsod is the best person to explain this third ground because he sponsored this provision on accountability on the impeachment process, and in his sponsorship speech in the 1986 Constitutional Commission, he said the intent of these provisions is to liberalize the impeachment process because of what happened in the past. It was so strict that you can hardly file an impeachment case. So they liberalized it, but now the Supreme Court ruling will make it very difficult. It's against the intention of the framers of the Constitution. So thank you.
On that note, Chairman Monsod, can you give us the historical background of this liberalized impeachment process?
Well, the first point there is that there was a proposal that the Supreme Court be the the Supreme Court should be the court, and that was voted down because the impeachment is a political act, and it might even politicize the Supreme Court also because the respondent may be a member of the Supreme Court. So the role of the Supreme Court in the impeachment process was reduced to strictly constitutional issues. Now the decision that they rendered the Supreme Court may have overreached the power that given to them under Section 1 of Article 8 to determine whether there's grave abuse of discretion amounting to lack of excess of jurisdiction on the part of any branch or instrumentality of government, may have overreached that, because they even went into the meeting of the House of Representatives regarding the complaints. This was not a hearing. The only hearing in the Constitution is the one that's in the Senate, and the court said that it was a hearing, and therefore the respondent, the Vice President, should have been informed and be allowed to express her views. That is wrong. That is not contemplated by the Constitution. The due process is observed in the hearings of the Senate, not in a meeting of the House of Representatives. One of the issues here was the House of Representatives correct to verify a complaint? Yes, it was correct. Is the fourth complaint valid? Yes, it is. I think Justice Carpio already issued a statement on why it is valid, and said, did it violate the 1-year ban? No, it did not, because precisely, as already explained by Justice in the Isambayan statement, he even had the exact time when it was approved, and it was before the 3 complaints were managed and handled and declared as dismissed. So in fact the tolling of the 1 year starts from the fourth complaint that was reached. And now, was there due process? I already answered that. But in law, they call that the operative doctrine that was explained already by Justice Carpio. And also it was mentioned by Adolfo Ascuna, who said that it may be lawful, but he always, but it is unfair. Justice Ascuna, even during the Constitutional Commission, was a very kind person. He was saying something that was very important, and he was right. And there is a point that he made, which is really, when you bring it down to facts, is that did the Supreme Court overreach its powers under Article 8, Section 1? And I think that therefore there is a motion for reconsideration is really due, because bottom line, that may be the basic issue. Thank you.
Okay. Given this very clear opinions rendered by our 2 gentlemen, can I ask a direct question which both of you can answer? So the Supreme Court said the articles of impeachment are unconstitutional. So there is no longer any complaint against VP Sara. Do you agree or not, and why, Justice?
Well, I do not agree, because the premise of that ruling is that the House did not approve the 4th complaint. Sabi nila, there was no approval of the 4th complaint. But there was an actual approval. It's there in the records of the House. There was a motion, and then it was even unanimous. Nobody objected. So, and the decision says there was no approval, citing a news report. A news report, when the court could have easily asked that question, did you approve it? If they could have shown the records, it's there. The journal is there. So
The House Journal itself,
Yeah, the
which you
House
sent to
Journal.
me, the 27-page journal.
Yeah, I said it to you. So it's so basic, fundamental, that it deserves the consideration. Because, the court will lose credibility if they say there was no approval by the plenary when in fact there was an approval. The court complained.
More than one-third, 215 votes.
And more than one-third, 215 voted for that articles of impeachment, and nobody opposed it when there was a motion in the plenary to send it to the Senate. There was no objection. The time is there, 3:30 something, 3:37. They approved it. It reached the Senate, 4:57, same afternoon, and the House adjourned at 7:15. So klarong-klaro. And the court said, upon adjournment, the one-year bar rule took effect. So it will not affect the court complaint because it was already approved at 3:57 p.m. And basic ito, the court should not have relied on the news report that is not official.
Ito, nasabi ko, Chairman Monsod kanina, devil's advocate, sabi mo yung 317 or 27 approve yung fourth impeachment complaint. And after that voting, there was a motion to archive the
Correct.
3 impeachment. So, approve din yun. So, it really, kung ang reckoning on same day, mas nauna yung voting ng fourth impeachment kaysa sa archiving.
Very good. Yeah, correct. Very clear. It cannot be denied. So, it's factual.
So kaya nga sir, pag mas nauna yung voting kaysa yung archiving, so it is consistent with the Supreme Court ruling na carry out yung fourth impeachment when na-archive na ngayon tatlo on the same day.
The tolling of the 1 year started when the fourth complaint was approved and sent to
Yes.
the Senate.
Yes. So on
So
that,
it applies to the 3.
yes.
Yeah, it will apply. And there is something here. If you look at the complaints, the House really looked at the first 3 complaints and found them wanting. So gumawa sila ng fourth complaint to strengthen it. And they took elements from the first 3 complaints. So the fourth complaint was a composite complaint. Included there are the strong arguments of the first 2 complaints plus additional arguments, additional allegations. So it actually substituted.
Yes.
So even the sponsors, even those who endorsed the first 3 complaints, the congressman who endorsed the first 3 complaints, joined in endorsing the fourth complaint. So how can you say na there is a conflict? Wala.
Oh, another counterpoint na layman's saka devil's advocate na rin. The 3 impeachment complaints, first 3, went through the process. Secretary General na submit, then refer to the Committee on Justice. But the fourth one, which was voted upon on that day only, presented and submitted on that day, was voted upon but did not go through the required process na submission to the Secretary General and referral to the Committee on Justice.
Actually, what happened was the fourth complaint was submitted to the Secretary General because that is what the House rules state.
Okay.
If it is a direct filing by 1/3 at least of the members of the House, it is submitted to the Secretary General, and it was submitted on that day. Maybe it was submitted noon or before the plenary session started.
Kasi,
So it was actually submitted. And
yung parang baga yung porky in-house made yung complaint, it went through the process, ganun kabilis lang.
yeah, because the Constitution says the complaint must be included in the order of business within 10 session days. So even on the last day, it complies with the Constitution. And that's why they were very conscious of that 10th session day. And that's why they did everything. It took some time to put together the fourth complaint because it was well written. So they took elements from the first, second, and third complaint, added, saw to it that all the attachments are there. And that's why it took them on the 10th session. But they were aware that they have to do it before the end of the 10th session day. So umabot talaga sila. That's why even the court said, yes, umabot yan. Pero ang akala ng court, it was the first three complaints that were acted upon.
Okay. Chairman Monsod.
But, you know, the thing is, that's the power of the House. The
Yeah.
power of the House to combine complaints. Now, people are asking, ano ba yung session days, 10 sessions days? Because it doesn't appear to match with calendar days. But the decision of the court accepted the definition of session days. That it can, for example, three days of hearings, that may be only one session day. It's not equivalent to a calendar day. That is accepted. That's why people are asking, bakit umabot ko sa February 3 to 5? It's because of the definition of session days. Yeah, we followed up. That's actually the American way. They call it the legislative.
The February complaint was submitted on February 5. On July 8, the Supreme Court required the respondents to provide details not required in the Constitution and probably had nothing to do with the law. Your thoughts on this?
Verification of the content. No? They were asking to make sure that the complaint would be complete. So it's within his powers to ask that, I think.
Justice.
Well, it's within the prerogative of the Supreme Court to send those questionnaires, interrogatories. But the better practice should be to call for a oral argument.
Yeah.
Yeah,
Which
because
it did not, di ba?
They did not. Because in very important constitutional cases, always there will be a oral argument, because it is in the oral argument where you can really see the entire picture. Because
Yes.
the lawyers will have to answer candidly to the court.
Yes.
So, like yung problema na whether the court complaint was approved by the plenary or not could have been asked there. They did not include that in the interrogatories. They did not ask that question. Very crucial. They just assumed that because of a newspaper report, it was never taken up. But that's basic. So there should have been an oral argument. I agree with the Chief Justice Pangaliban. You have to call an oral argument. It's not mandatory, but so that you will have, for you to have a overall appreciation of what happened, you have to call for an oral argument.
So we move fast forward. The House responded. Yeah, the House responded to the Supreme Court questionnaire on July 21, Monday. Then we had rains, you know, the three rains and floods and bagyo. Tuesday, Wednesday, Thursday. So no work, no en banc session of the Supreme Court. Then Friday, they called a special en banc session to discuss the matter. But the same day, they, with Justice Leonen as ponente, issues a 97-page decision. Being a former justice senior self, is that possible? How did they did it? How did they do it?
Well, probably they already prepared the draft earlier. I don't know how they did it, but it was very fast. So they must have done their research earlier.
Chairman Monsod, do you believe that?
Possible.
Looking from the
It's
outside
possible
looking
to
in.
do that they were prepared. So,
Uso na AI naman, eh, di ba? AI chat, pwede na ma-AI yan. Oh, so, was it significant that Justice Leonen, being a Pinoy appointee, was the ponente, since all other concurring justices were Duterte, Pinoy, at combination. Pero yata panay Duterte appointees. What is the process? How do you... So, sir, speaking from your experience, you were an appointee of former President Gloria Macapagal-Arroyo, di ba? Is the appointing authorities have something to do with these decisions? Were you guided by that?
Well, I voted many times against the position of former President
Gloria.
Gloria Macapagal-Arroyo.
So it cannot be used as an argument na kasi Duterte appointees kaya nag-side kayo, ano, ganon.
You cannot apply that to Justice Carpio because he has very dissenting opinions.
Yeah, well, Justice Leonen is the ponente because I think it was raffled to him.
Okay.
The case was
By
raffled to him.
raffle,
Yeah,
by practice
This is
yun.
assigned by raffle to
Okay.
the justices.
Kasi di ba,
Have you read the study published by
Cambridge?
yeah University, Cambridge University? Have you read it? Where they examined the voting pattern of just 80 justices in 70 major cases, and their findings was that in general the justices voted 69% in favor of the government appointing power.
You mean in
But
the US
the,
setting, US setting, ha? Philippines?
Philippines. It was published in 2023.
Mhm.
And then the justices appointed by Duterte, the figure was 94%
Wow.
of their vote was for the government. There was a succeeding study also published by Cambridge in 2024 saying that Indonesia and the Philippines are headed toward a authoritarian government
Because of those decisions?
because of weak institutions and wrong policy.
The checks and balances,
And
you mean?
also because of the problem not only of poverty but inequality.
The decision in one of the footnotes, I think this is what Justice Carpio is mentioning, used an ABS-CBN report that there was no plenary at the House on February 5. This report was wrong because there was a motion by Congressman Dalipe. Paano naging major point of the decision is based on the wrong information? Can the Supreme Court correct its own mistake?
Yes, it should. Because there's a motion for recon. The purpose of motion for reconsideration is to correct any error.
So, hindi na motu proprio yan.
No, I think the House already announced that they will file a motion for reconsideration.
They have 10 days?
15 days data, 15
10
days.
days.
15 days.
15 days.
Oh. But the Senate announced yesterday that they intend, as far as the Senate President is concerned, speaking as a Senate President, he cannot speak for the entire 24, di ba, sir? Sabi niya, as far as it's concerned, I will comply with the Supreme Court ruling na void ab initio ang impeachment complaint. But we have to hear the majority, but we will discuss it through the legislative body and not as an impeachment court because there is a Supreme Court ruling. We might be held liable for that. Any sentiment for not for respecting the Supreme Court decision is shared by fellow senators Jingo Estrada, Mick Subiri, Cayetano, I think. Anyway, sir, your thoughts on this matter?
Well, if the decision becomes final, of course we have to follow the final ruling of the Supreme Court. It's the final arbiter. Whether it's correct or not, that's the final ruling. We have to wait for another occasion when it could be reversed. But it's not yet final. It's only executory, but not yet final because the House still has a motion for reconsideration. So I would think that the Senate should just hold in abeyance any action because it's not yet final. Normally, you you act when it's already final. Because there's a chance, because it's not yet final, there's still a chance it could be reversed or changed because there's a motion for reconsideration.
Does,
I think the Supreme Court should rethink its decision, because the whole purpose of impeachment is to protect the people from betrayals of public trust and, graft and corruption and so on. What if the charges are true? They have postponed the filing 1 year. What harm is that to the people by that decision? So I really hope that the Supreme Court will study well the motion for reconsideration and what the effect is on the people of postponing any complaint for 1 year, right? If you read through the purposes of the impeachment process, it is there that while it may not amount to a criminal act, the impeachment is there precisely to protect the people from public officials who have betrayed the public trust.
Chair, Justice.
Yeah, I think the Supreme Court should reconsider because the rules that they provided now, the new rules, will practically make it impossible to file an impeachment complaint. Why? Because the Supreme Court is saying at the plenary level, you must give a copy of the draft of the articles of impeachment to the person being impeached. And then once you decide to file it, before you decide to vote and vote on the, you have to give a hearing. It cannot be ex parte. So there will be a hearing at the plenary level. Ang problema, the Constitution says that the impeachment complaint should be referred to the Committee on Justice within 3 session days from the time it's included in the order of business. 3 session days, I don't think that's enough for the plenary to debate on the articles of impeachment, to draft it, and then after agreeing that it should be adopted, not yet to vote on it, to notify the person being impeached and allow him to file his answer or comment, and then there will be a hearing because the person being impeached must be given a full opportunity to rebut. And then I don't think you can do it in 3 session days. And then after that, when the plenary will still vote to refer it to the Committee on Justice, you will replicate the same procedure. There will be another hearing. So doble. So I think that's not the purpose. The constitutional, in the deliberations of the ConCom, they said the purpose of this procedure that they laid out is to relax the requirements, to make it easy to file these impeachment complaints.
With these points, legal experts weighing in, the constitutionalists coming out with their opinions, will this influence the Supreme Court in deciding when the MR is filed? As a former justice.
Well, I think they read the papers, and also I think the motion for reconsideration of the House will include this, no? Because they are also listening to us.
No.
And they already issued a statement that I think the spokesperson of the House already mentioned the 2 basic issues that the House actually approved in plenary the 4th complaint before the first 3 complaints were dismissed, and they also said that you have to apply the doctrine of operative fact. Otherwise, there will be no due process. So they know also. I mean, they have good lawyers, so they know also.
Yeah, yung sinasabi ni Chairman Monsod na operative, sir, you might.
Sorry, operative path doctrine.
Oh.
Yes.
What's the...
When the decision came,
mm,
there were many things that have already happened.
mm-mm.
The articles of impeachment was accepted by the Senate. The Senate issued summons to the Vice President. The Vice President answered. The House replied already. A lot of things had already happened. They are negating everything. They are saying, well, all of that is set aside. Can you imagine? That does not follow the purpose of the impeachment process that's in the Constitution, to liberalize it and to act quickly on it, that it should be done quickly. Here they are, they're jumping over things that have already happened and all due process, and then on top of that is the 1-year prohibition. Is that correct? I mean, or are they overreaching their powers?
There's another point here because under the Francisco Doctrine,
Yes, sir.
the 1-year bar starts to run when the plenary refers the complaint to the Committee on Justice and it is received by the Committee on Justice. So there is a favorable action by the plenary to refer it to the Committee on Justice. So it's not dismissed. So the 1-year bar starts to run. But this decision of the Supreme Court says when it is dismissed, the 1-year bar also starts to run. So whether the plenary approves it or dismisses it, the 1-year bar will start to run.
Pero sabi nila sa decision, February 6 onwards, pwede nang i-file.
Yes, because the purpose of the bar is so that the public officer will not be harassed by multiple suits.
Mm.
So there is that bar. You can only file it once.
Oo.
But if it is dismissed, there is no harassment because it did not even reach the Committee on Justice. There's no hearing.
Mm.
So why will you apply the 1-year bar rule when the plenary dismissed it? There's no point. You only apply the 1-year bar rule if the complaint is approved and the process continues because that will now take the time of the public official being impeached.
So what are you saying? It should not be February 6.
No, I'm saying if it is dismissed, there should be no 1-year bar rule. Dinismiss nga eh.
Okay.
Because why will you apply a bar when, let's say,
So, saan dapat ang bar mag-start, magre-recon?
under the Francisco ruling, when the complaint reaches the Committee on Justice.
Okay.
So therefore, there is a reason for the bar para wala ng harassment, isa lang.
Okay.
But if it was dismissed, wala talagang harassment, dinismiss nga eh.
O kasi na-dismiss, na-archive noong February 5 din.
Yeah, so the public official is not inconvenienced at all. Dinismiss eh.
Mm.
But if they favorably recommend the continuation, they will tell the Committee on Justice there's probable cause, continue, then the public official will have to appear,
Yeah.
defend himself. That will take his time. So that is why there is a 1-year bar rule para you can be inconvenienced only once.
But the same Supreme Court ruling invoked the Bill of Rights for the right to due process.
Well, mali nga eh. Because
Explain nga nyo, bakit mali? Ako nalilito na.
because the
Parang
due
may
process is
contradiction yun
different.
na eh. Oh.
The due process is different.
Oh.
The due process says, for you to be held liable for an act, there must be a prohibition at the time you perform the act. Diba? Simple lang. For you to be liable for a crime, there must be a law prescribing that act is a crime.
Yeah. Oh.
Pag walang act prescribing the crime, and you did that act, but later on, the law says that is a crime, it cannot be made retroactive because at the time you performed the act,
Hindi
it
pa
was
bawal.
valid.
Oo.
Ganyan din. At the time when the House approved the fourth complaint, there was no requirement to hold a hearing.
Oo.
Ngayon lang ini-impose. You cannot make it retroactive because the action of the House at that time was valid. You cannot invalidate it with a new regulation that is imposed 1 year after.
Okay.
The court was wrong. They were applying that due process to the House meeting where they were voting on
Not the hearing
charges,
itself.
right?
Oo.
It was not a hearing.
Oo.
And they
Plenary
said
nga
that they said that the House violated due process by not informing the Vice President, so the Vice President can defend herself.
Oh.
That happens in the hearing in the Senate.
Yes.
So even the basis for the Supreme Court ruling of lack of due process is wrong.
Dapat sa trial mismo yun.
Yes, they were referring to the House meeting.
Oo, plenary session yun. Different from the hearing.
Yeah, that is correct. Plenary session will not conduct a hearing unless the plenary is declared a committee of the whole.
Yeah.
The House always
Tsaka
acts
question
through
hour.
committees.
Oh, yung question
always
hour.
committees.
Yes.
Lahat yan, the plenary will refer it to the committee.
Oo.
But for the plenary to conduct the
A
hearing,
hearing.
it will have to declare it as committee of the whole.
O kaya question hour.
Oo. So,
That was not the case.
yeah. Parang ano yan eh, mag-file ka ng complaint sa piskalya, sa prosecutor's office. The chief prosecutor, will read it and then refer it to an investigating prosecutor. Walang hearing doon.
Oh.
Ang hearing sa investigating prosecutor. Ang plenary is like that chief prosecutor. Di-decide niya, okay, I will refer it to the committee. Walang hearing doon.
Oh, jumping to your dapat nung February 5 kung yung fourth impeachment i-approve, dapat pinatawag si VP Sara to di ba, to write to answer there right there and then, no?
Hindi, wala
Para
kasi,
mabigyan ng semblance of due process.
hindi, kasi
Hindi na.
because
Kasi nga dapat committee of the whole.
yeah, if they declare themselves as the committee of the whole to conduct the investigation, but they did not declare. So, it's like the prosecutor, pag nag-file ka sa prosecution office, before he makes the decision to refer it to investigating prosecutor, there is no hearing.
Yeah.
Ang gusto nila, may hearing.
I understand your point. Sasabihin ko, ang comment ko lang talagang palpak tong house sa paggawa ng kailang impeachment.
No, actually, they were wrong.
Oh, who's they? The Supreme Court.
They were referring to the meeting of the House where they said the process was not
Okay.
Ay, ganun.
Pinapatay mo yung microphone niya. Okay. Ito, isa magandang point, sir. For both gentlemen. If Supreme Court stands its ground despite these obvious mistakes or errors that you are pointing out, will we have a constitutional crisis? How? In what form? What is the solution? Kasi yan ang mga concerns, di ba? From Senate President, former Senate President Franklin Drilon, the Mixubiri, et al.
Well, I am a rule of law person,
Yes.
so, and I accept that the Supreme Court is a final arbiter. So, we have to follow, even if it is wrong, even if we think it is wrong, that is the final decision. But we have to be aware of history. Diba, yung impeachment ni former President Estrada, they did not open the envelope.
Yes.
And we cannot control what happens after that. So, but for me, we have to follow the final ruling of the Supreme Court, even if it is wrong, and we wait for another occasion to correct it if there's another case. But because I follow the rule of law.
Okay. Chairman.
Well, I think that there are options open to people. That's why we have an ombudsman. And the office of the ombudsman is in the same Article 11. Now, what can you bring up to the ombudsman? Something that's illegal, unjust, improper, or inefficient. And in fact, when we were writing the Constitution, there was a proposal na yung ombudsman dapat sumbungan ng bayan. So there is no option still open to people to complain about the Supreme Court. Under the Article 11, the officers that may be impeachment, right? It doesn't say it's the only way that we can hold the public official accountable.
Impeachable official. Impeachable official.
No, it's not it may not be an impeachment.
Yes.
It may be a case.
Yes.
Against, but with the help of the ombudsman. That's
Pero
why
di ba,
it's
sir?
important that the ombudsman is a very good one. Like, before it was Carpio Morales.
Yes.
Right? And now I don't know the
Pero
new
sir,
one.
kasi constitution ka, di ba, ang VP is one among those impeachable officials immune from suit while in office? VP.
No, the president.
Only the president? And only the president is immune from suits while in office?
Yeah.
Under
Only the
Constitution?
president.
Only the president?
It doesn't include the vice president.
Okay. So that option is open. The same impeachment, articles of impeachment can be raised before
Don't call it impeachment. You just call
the complaint.
the complaint
Oh.
to the
To hold her
ombudsman.
accountable.
And
before
there are
the
many
ombudsman.
things the ombudsman can do.
Okay.
I mean, you can file a case,
Oh.
right? Different from an impeachment case.
Criminal and graft
Right.
complaint.
In fact, if you're successful in impeaching her,
Oh.
remove from office
Public
and
office.
that's all. It's
Yeah.
a political act.
Okay.
You can file cases even with that. What more if you believe that the Supreme Court did something wrong?
Okay. Justice?
Yeah, well, it's not really the end of the world, no, because after February 5, 2026, the impeachment can be refiled by the House.
Yes.
So this is just a delay.
Oh.
So that's about 6 months. About 6 months. You just have to wait for 6 months, and time will pass quickly.
Uh-oh.
So there's still a remedy. They can refile. The same this House now can refile it starting February 6,
Yes.
2026.
Oh.
Then-
Bukas, August na eh.
Oh, August na bukas.
September, October, November, December. January, 6 months.
Yeah, 6 months, then it can be refiled. So,
And better and according to the laws and Constitution.
according to this decision.
Oh. I'm just curious.
My
Opo.
point
Yes, sir.
is that the people have many options.
Yes.
That's what when we were writing the Constitution, we say, do not give the people a dead end.
Okay.
So that if the Supreme Court made mistakes or were wrong in what they were doing or unfair, unjust, and so on, then the people can go to the ombudsman.
Okay. And the ombudsman is also subject to impeachment.
The ombudsman, even the president can be investigated by the ombudsman, but he cannot file the case.
Only
Right?
investigation
Yes,
lang.
But he can have a result of an investigation that people can avail of in filing the cases.
Pwede pala yun under our Constitution.
Yes. The ombudsman can investigate
The president.
Yeah,
Okay.
the ombudsman can investigate but cannot file the criminal case.
Okay.
The House can use that to impeach. But there is something here,
Yes, sir.
because this is a provision on accountability.
Oh.
My worry is that because of this ruling, if the impeachment complaint is dismissed, the one-year bar rule still applies.
Okay.
If the impeachment complaint is filed, brought to the Committee on Justice, the one-year bar rule is applied also. So you actually prevent people from filing complaints. Kahit na the first complaint was dismissed, you say no second complaint for 1 year. In either case, it doesn't make sense. It does not. There's no reason why, pag na-dismiss, you should apply the 1-year bar rule. But the court here applied it. I cannot understand.
You mean to say, yung sa Supreme Court ruling is clearly stated that these these 4 impeachment complaints cannot be refiled?
Refiled within 1 year. Kahit na-dismiss.
So,
That's kaya sabi nila, February 6, 2026 na kayo makarefile.
Oo.
Pero dinismiss nga eh.
so effectively, pati the entire complaint,
Well, yeah,
hindi na
well-
pwedeng i-refile, you mean?
Within 1 year.
Within 1 year.
So,
And not even to the ombudsman?
but no, different yon.
Yung pwede.
Yeah, but it doesn't make sense na pag final mo, tapos umabot sa Committee on Justice, the 1-year bar rule will apply. Pag hindi umabot, dinismiss, the 1-year bar rule will still apply. It doesn't make sense. Because the purpose of the 1-year bar rule is, pag na-impeach ka, tapos you go to that process, it should not be repeated. Dapat there's a breathing space for you. There should be no harassment. Pero pag dismiss, walang harassment eh.
So, what is the solution you see for Supreme
That's
Court
why I say,
to save face? To save face
the court will have to reconsider.
through the MR.
Yeah, because it doesn't make sense.
From your experience, pag unanimous ang decision, it's nearly zero impossible to reverse it.
Well, there were reversals before,
But this is a unanimous decision, 13-0.
but then it's so obvious. The records of the House show they approved it, and the Supreme Court said the 4th complaint is void because you did not approve it. In-approve talaga nila eh.
So if the Supreme Court rejects, in case, the MR of the House, kailan pwede i-file? December 3 this year or February 6 next?
February 6, 2026.
Okay. So, nabanggit to ni Chairman kanina yung liberalizing the impeachment rules, di ba? Now, because of the Supreme Court ruling, has the Supreme Court been politicized? What are the dangers to our republic if that is so?
Sorry, I didn't get
You
the
mentioned about liberalizing the impeachment rules, di ba, sir? To protect it from being politicized.
question.
Because of this ruling, may perceptions na politicize ang Supreme Court because of this ruling, dismissing the impeachment against VP Sara. What are the dangers to our republic now if this is the case? What is the solution to this?
Well, that's what I'm saying. The people cannot be out of options,
Yeah.
right? We have a democracy. People are accountable for their actions and so on. And it's not just when you talk about, we're talking even of the Supreme Court.
Yeah.
If they think they are immune from people action, they're wrong.
Because they're impeachable.
Because we can go to the ombudsman, there are many things that people can do for the country.
Okay.
And I think that the Supreme Court should rethink their decision and say, is it good for the country, and what are the consequences to us of doing this?
Okay. So my last question is for the justice, because he was once several times acting Chief Justice. They are asking, why is now Carpio completely opposed to the 13 justices? What is he trying to do with this former institution? What happened to the gods of Faura when the former god is still
Well, I'm
attacking
not
them?
alone. There is Chief Justice Panganiban. There's Justice Ascuna. Well, we are now private citizens.
Yes.
We have freedom of expression. And nobody can prevent us from speaking because we enjoy freedom of expression. And freedom of expression is the freedom without which no other freedom can exist. And that's why we hold dear freedom of expression. We will exercise it because without freedom of expression, the other freedoms cannot exist.
On that note, I'm opening the floor for your questions. Medyo, kayo naman, at nosebleed na ako rito. SOS, kayo naman. Nosebleed ako dito. Maki, isang ka. Tsaka si Adrian.
Nosebleeding din po.
Baka ma-anemic ako dito. Ayan si Sir Maki.
Sir, Maki po.
Pulido pang GMA 7.
I just want to clarify, kay Attorney Monsod po, I just want to clarify what you said about the people can file a complaint against the justices sa ombudsman kung halimbawa po sa tingin nila ay hindi makorek yung mga what you said were blatant errors dun sa decision.
An option, the people can go to the to file complaint against the justices.
Well, no, but I think the people are not bereft of any options for government officials who betray the public trust, right? Remember, maybe the most important provision of the Constitution is sovereignty resides in the people, and all government and authority emanates from them, meaning that government officials are servants of the people or agents of the people. And when they do not do what the people want or what's right, the people always have options under the Constitution. That's what I'm saying. Don't think that they are free and they can freely do what they want even when it's wrong.
Sir, last na po. So yung option po ba na yun is to go to the ombudsman?
As the ombudsman cannot file, the ombudsman can investigate and then get to the truth, and that can go public when they get to the truth of the situation. And there may be cases filed separately, but the ombudsman cannot himself file.
Yeah. They file it to the Sandigan Bayan.
Yes.
They can investigate and find out the truth. Okay. Adrian, ikaw naman mag-nosebleed.
Balikan lang po yung dun sa, sa one-year bar. The SC decision also addressed it. So you still think po na yun nga, kahit unanimous yung decision, pwede pang ma-reverse yung decision ng SC?
Yeah, theoretically pwede. I mean, there's no rule or law or constitutional provision saying that they cannot correct themselves.
Pero may precedent na ba? Sir, marami ng precedents, di ba? Na ni-reverse niya ang sarili niya.
Yeah, there are many precedents already that the court completely reversed itself, like in the Labugal case, the mining case. There are many cases.
But they can also correct themselves on some parts, no,
Yes.
of their decision and say, no, this is wrong, so on, but this is right.
Yeah.
So there can be partial changes.
Correct. Yeah.
Also in the reconsideration.
Yeah, the proposal of Justice Escuna is the court will make their decision prospective. It will not be made retroactive. So they maintain the core of their decision, but the applicability will be made prospective. That's one of the proposals.
Okay.
Yeah. The new rulings is going to be prospective.
Yes.
The new rulings, they can correct themselves on that, which means good for us, right?
Impeachment will continue.
Yes, impeachment will continue.
Pero swerte pa rin si VP Sara kasi may 1 year pang hintayin, 6 months pa.
No, hindi.
No more.
Hindi,
more.
hindi i-apply yung mga bagong rules nila.
Okay. Parang kumbaga void ab indicio una.
In other words, the proposal of Justice Escuna that the court adopt the doctrine of operative fact will
Ayun
apply.
pala yun.
Na yung from now on, this is the new rule.
Okay.
It will not cover past
Okay.
actions of the House.
Okay.
And that means that the trial can continue.
Okay. So, win-win yun. And that would be win-win solution.
Yeah, that will be, at least for this case, that will calm the people. No?
When you say the trial can continue, you mean the present Congress now acquires jurisdiction?
The Senate acquired jurisdiction because if you make this new doctrine prospective,
Oo.
you apply the old doctrine to the case of Sara now.
Oo.
So the case in the Senate will continue.
Teka sir, baka ano ha. So kasi sabi ng Senate Chief sa August 6, convince sila as legislative body to determine whether to continue or not. Besides kung anong individual stand nila. Maski baka kasi nga majority rules eh. Kung manalo yung, sige, continue. They can continue even if the Supreme Court has yet to rule on the MR.
Well, I think to comply with the ruling, because it's immediately executory,
Oo.
they just
Stop
stop and
in
wait
abeyance.
wait for the ruling on the MR.
Okay. Hold in abeyance muna.
Yeah, hold in abeyance muna.
Okay. So, may question daw kayo? Okay.
Justice Carpio. Sir, tama po ba? Yung mic.
Okay.
To Justice Carpio po, sir, tama po ba yung binanggit or yung narinig ko kanina na dapat ang SC magtakda po ng oral arguments dito po sa kasong ito?
They have the option, and that is the recommendation of CJ Panganiban. That's also my recommendation, na magkaroon ng oral argument before they decide the motion for recall.
Well, on the MR. Gandang suggestion yun. Okay.
Hello.
Teka muna.
Good morning po, Justice Carpio. Joel Sanon po from Business Mirror. Are you still optimistic na magkakaroon ng impeachment proceedings before the Senate, considering po yung due process requirements na nilay down ng Supreme Court and the one-year bar rule, plus yung compliance or non-compliance dun sa due process requirements by the House may still be subject of another petition before the Supreme Court. So, are you still optimistic na may uusad na impeachment?
Well, I'm optimistic that at the end of the day, the Supreme Court will decide correctly. And I'm optimistic that they will consider very seriously the motion for reconsideration because there was really a factual mistake. But let us assume the Supreme Court does not change its ruling. Then we just wait for February 6 because under the ruling of the Supreme Court, it can be refiled starting February 6, 2026. So 6 months lang. So there will be an impeachment case really. It's just delayed nga.
Pero po yung compliance po by ng House dun sa due process requirements or maybe non-compliance sila, pwede pa pong i-question din yun ulit sa Supreme Court.
Well, the House can, by February 6, 2026, if the House will refile it, they have to follow the ruling already.
And kapag hindi po na-follow,
Pareho din.
pwede aakyat na naman po sa Supreme Court.
Yes. So the House will, because this is a direct filing, they will conduct a hearing.
Sino dapat sisihin kung sakaling until February ba maganap yung trial na kung saan magdidesisyon by August 6 yung Senate as legislative body tapos mag-stand tayo si Supreme Court sa una nilang decision? Sino dapat sisihin dun sa pagkabili ng mahabang trial against President? Sino dapat sisihin?
Sino sisihin? Sino nagkamali?
I don't think it should be finger
Yeah,
pointing.
I think what we should do is, okay, andyan na yung decision na yan. We can, the House
Correct
can
it.
refile February 6. Well, let's just wait for that. Kasi andyan na yan.
Should the Senate also blame for not acting immediately since under the Constitution is forthwith?
Yung forthwith na naman.
Yung forthwith. Yun nga ang problema because there's still a case there in the Supreme Court on the forthwith. They did not deal with the...
Hindi ba yun?
No, the ruling does not discuss the forthwith there.
Oo, yeah.
So, that's still an open question. Ano yung meaning ng forthwith?
Oh.
Pero ngayon, since the Supreme Court said, once you, if there is a direct filing by at least one-third of the members of the House, magkakaroon kayo ng hearing. So yun na yun. Hindi padala kagad sa Senado.
Since the impeachment process is a political process, do you still trust with the senators who will handle the impeachment cases? Do you still trust with the senators since it's a political process?
Well, they are the senators. They will be the one to decide. We don't have a choice. So we live with what their decision. Whatever is their decision, of course, if it's against the Constitution, provided there's specific violation of the Constitution, katulad ngayon, you can go to the Supreme Court. But if there is no specific violation of the Constitution, then there's nothing you can do. You have to accept that decision.
Okay.
Ma'am, ay,
Okay.
hello
Tanong
po.
mo.
Morning po. Justice Dante Mento, BNTV. Ang question ko lang po doon sa argument din po ni VP Sara. Kasi noong na-file po yung tatlong complaint, December 2, 4, and 19. And based doon sa wording po ng Supreme Court, in-archive. Wala po bang violation doon sa due process? Which is a constitutional provision din yung speedy trial and disposition of cases po.
I don't think there's any violation. Katulad ng sinabi ko, yung fourth complaint was adopted before they archived. And the fourth complaint contained elements of the first, second, and third. And in the Francisco decision, the court said, the plenary can adopt its own articles of impeachment and combine all the others to make it stronger. That's exactly what they did. So there is no violation of due process because, in fact, those congressmen who endorsed the first three complaints signed the fourth complaint. Sabi nila, itong gusto namin, mas matibay ito. So there is no really violation.
Any more question? If no more question, my last question to both gentlemen. I'm sure they will be listening and reading your opinions on this matter. And if you are to advise the present 20th Congress, what would this be in a specific case in this impeachment? Chairman Monsod, let's start off with you. Following the Constitution, what would be your advice?
Well, the 20th Congress can continue with the trial if there is a change in the Supreme Court decision. I think we should remind our public officials that the accountability of public officials, the accountability is not only about impeachment.
Okay.
As I was saying, there are options open to people, but there is also the option with respect to the senators and the congressmen. There is also the option of the people how to vote, who to vote for in the coming elections. There are many ways by which we can make our public officials accountable, and those are just some.
Okay. Justice Carpio po.
Well, I urge the House to file a motion for reconsideration because under this new ruling of the Supreme Court, what will happen it will be very, very difficult to file an impeachment complaint, practically impossible because of a timeline. And it doesn't make sense to me that if it is dismissed, the one-year bar rule will apply. So I think we have to ask the Supreme Court to revisit its decision for the sake of the nation, because as Commissioner Chairman Monsod said, this is a provision on accountability of our highest officials. And we have seen it before that when this accountability is endangered, what did the people do? You had EDSA too. So we want to avoid any disturbances, and that's why I urge the House to file their motion for reconsideration. Thank you.
Sige.
I just want to say
Opo.
to our public officials, don't underestimate the people.
And on that note, I would like to echo the calls of our gentlemen guests who shared their legal minds and constitutional expertise on these raging matters. So I hope our 20th Congress can take note of this, and as well as the Supreme Court. Good luck to the gods of Aura. Are you still able to talk with them, with your fellow gods of Aura? Okay. On that note, we thank them, especially Chairman Monsod and Senior Associate Justice Carpio for gracing our Kapihan sa Manila Bay. Hope we are able to inform everybody of the right understanding of the impeachment trial issues. Thank you very much. Sir, please accept our